SJC-13927, Caroline Pineau et al., the Andrea Joy Campbell, Attorney General et al.
Okay, Attorney Fine.
Thank you, Chief Justice Budd, members of the court. It's an honor to be here today, my first oral argument before this court on a very, very important issue pertaining to a ballot initiative that, in our estimation, is severely flawed. It contains unrelated subjects, and its summary, which is the first line of protection for the voters, is grossly deficient. And I don't mean to be hyperbolic, but there are many, many features missing from the summary. I want to start, Your Honors, by talking about what is the purpose of this initiative, because I think it's very important to frame. The plain language of the petition itself talks about one, well, let me start here. The Attorney General will summarize it as, in its brief, as to constrain the use of medical marijuana by adults. That is one purpose that we see in the brief of the Attorney General. In the plain language of the initiative, we say there's another purpose, which is to continue the medical marijuana program. And that, again, goes at the heart of the issue before this court. By taking a wrecking ball to 94G, which is not the initiative, which is not the 94G that this court saw or evaluated under Hensley. 94G in 2016 was exactly what the initiative was, which was question 4, which taxed and regulated marijuana like alcohol. But what has happened subsequent to that is that 94G has been substantially amended. And I want to highlight to the court a few ways that it has been amended, because I think it's important to the analysis of the issues here. The first way that it was amended was that whereas Hensley, the court in Hensley said, the reason why I think Hensley was part of a common scheme to tax and regulate alcohol is that it did not materially change the medical program. In other words, it did not abrogate the authority of the Department of Public Health. It did not, the issue in that case specifically was around, it touched on medical, right? So if we think of, to use a metaphor here, if we think of question 4 as a house, next to it we had question 3, which was the medical law, and that was regulated by DPH, the medical, and question 4 was to be regulated by the Cannabis Control Commission. It did not touch anything, it did not affect, it did not change the medical laws, the petition. In contrast, by taking a wrecking ball to 94G, we have an initiative that dramatically changes and dramatically diminishes the medical program. So right there, we have a contradiction. We have the medical, yes, there's certainly aspects of this that constrain the use of recreational marijuana by adults, but it does not continue the medical marijuana program. It does not keep the status quo. And I'd like to highlight a few things there. One is, the host community agreements, which
it would be helpful to be more specific. You know, wrecking balls stuff doesn't help us a lot.
Okay, yeah, well, let me be more specific. This is seeking to repeal the entirety of 94G.
So, and is the problem relatedness, or is
yes.
Okay.
And the summary, Your Honor.
So let's say there's a section of the general laws, 94, let's call it X, and it deals with a whole bunch of things. And there's an initiative petition that says, we're just going to repeal all of 94X. Sure, I mean, on some macro level, that's all related, because it's just a single proposed change. But you're asking that we look into each of the individual provisions of the statute and determine whether they themselves are related to each other as opposed to related enough to the petition generally. Am I correct?
Correct. I think the court.
And they don't have to be totally closely tied. So where's the line? Why does any provision of 94G, the elimination of 94G, cross the line of relatedness?
Sure. So I think the court has to do that, and I think that's what we're asking the court precisely to do. And I'll point out two things. One is, well, first I want to point out probably the biggest thing is just the social equity program. This was something that when the legislature amended, so 94G, when it was just to tax and regulate marijuana like alcohol, in 2017, the legislature came in and they did a couple things. One is they added a mandatory requirement for host community agreements, which is this court had taken up in Madeira. And then in 2022, and they started.
What I don't get about your argument is that you are referencing appropriately Hensley, right?
Yes.
You're saying that unless this is a one-for-one replacement of the petition in Hensley, it's unrelated, as opposed to whether or not this petition, standing on its own, suffers from relatedness or is related.
Yeah, I mean, maybe a good example I can give of just kind of when I mentioned the wrecking ball, and I'm sorry that wasn't helpful, but when we talk about relatedness, I think social equity is a great example. The purpose of social equity, if under Hensley, if in question 4 had included a social equity program that would apply to the medical program and apply to adult use, that would fund specifically appropriate.
But why are you
funds.
going back to question 4?
Well, because I think I think it's a good analysis to take, Your Honor, because it's exactly what we have here, which is we have the legislature who can deal with unrelated subjects. Legislators is meant for the legislator.
Why don't you address what this petition does and whether the topics under this petition are related or not?
Okay, yeah, I think let me start about one. Let me highlight one piece of this provision, which I think shows why it's unrelated. This petition, in getting rid of 94G, doesn't get rid of everything in 94G. One of the things it keeps is the transfer of product between individuals. In other words, 1 ounce of marijuana, it takes it out of 94G, it puts it into 94C. That is not operationally related to constraining the use of recreational marijuana. It's not coherent with it. And that is an example of cherry picking. That's an example of log rolling. They're not decimating the entirety of 94G. They are taking pieces of 94G and what they view to the voters as an act of a sensible policy, and they're forcing voters to make a choice on that.
Aren't they going to stand up and say, okay, we're getting rid of recreational marijuana, and that has a bunch of ripple effects on existing law, like the social equity program, from what I understand, was funded from the recreational. What, is that wrong?
Well, I think that is wrong, Your Honor. It's not only funded from the recreational. It's funded from donations, which it has taken donations in. It is funded from the fees of the programs. And to say that the legislature recently amended, if I could just.
Go ahead. I mean,
the legislature.
You're bopping from point to point. It'd be very helpful. That conceptually, they're getting rid of recreational marijuana and they're making a bunch of changes that correspond with that. I think they're going to argue that. And it would be helpful if you sort of work from that general concept a little more than just picking apart what they take of.
I think they tie back to continuing the medical program. Mm-hmm. So if we are going to say we're going to, if the goal here is to continue the medical program and constrain the use of medical marijuana by adults, why are we taking HEAs away from the medical program? Why are we taking the social equity program away from the medical program? That is putting voters in a difficult position, because if you believe that social equity is important, if you believe that the reparations for the harms of marijuana prohibition, which the legislator has addressed in 2022, and that was a big, important issue to them, and it was an appropriation, it wasn't something that could have come around by initiative. That was an important issue. They applied that to the medical program. They applied that to the adult use program. And if we're saying to these voters, you have a choice to make. You can, if you really don't like adult use recreational marijuana, you can vote against it. But they might want to keep that important program which remedies the harms of marijuana prohibition. And that's precisely the problem here, is the interplay, the impact on the medical program. I mean,
can you talk about something that to me is a little bit more problematic? It's not the stuff that they want to do to what's old, but the stuff that they want to do that's new. Talk about the emerging adults provisions, because the requirement now of drug awareness programs for emerging adults, that seems to me at least to be aimed at a different policy objective than restoring the world to what it looked like before this was enacted.
I agree, and absolutely, Your Honor, and I think that's exactly what this court said in Carney, which is like we're trying to lump in. I think it's unrelated. I mean, I think you can look at these things in buckets, and I think we talk about juvenile, how we should be treating 18-year-olds and juvenile justice provisions, right? We can talk about decriminalization. That is a separate issue Whether or not someone should.
But I'm confused again, and Justice George is ahead of me, but if we're going to make recreational marijuana illegal again, don't we need penalties? I'm not sure I follow why that's.
Those penalties are, we're changing the penalties. We're making it illegal, and we're also changing the penalties. We're changing the age.
But right now it's legal for an adult to have recreational marijuana, right? So don't you need, if you make it illegal, to do something to the penalties?
Yes, you do need to do something. You can simply take away what the adult program implemented, right? So it did expand as part of the common scheme in question 4. It did expand the amount that you can possess. But so yes, you do need to take them away to a degree. Now, I think adding that 18, the 21, making 21-year-olds go to drug treatment where it wasn't like that before, I think that is unrelated. But I also think, Your Honor, yes, you need to do that, which is precisely the example I gave before, which is if that's the goal here, why are we saying it's okay? Why are we cherry picking things and saying it's okay to transfer marijuana between adults? Well, why are we doing that? Another thing I would just point out, Your Honor, with respect to operational relatedness, and when question 4, when I talked about building the house of 94G, whatever, question 4, one of the things that was in there was we are going to open up.
Aren't you running it right up against the sort of flexibility we build into Hensley? I mean, Hensley does exactly the opposite of what you're saying, which is you can't cover all of these different permutations. And go ahead.
Yeah, no, respectfully, Your Honor, and I was on, full disclosure to the court, I was on the ballot petition, which helped craft the petition that Hensley ultimately the court reviewed there. And I would say that was very, very well designed, not to touch, not to degrade the medical program, which is what we do have here. And I want to explain that in a moment. Not to, the parts that touched the medical program in Hensley were it allowed adult use, it allowed medical, if they wanted to co-locate, right? And it allowed them to have priority. And that fit the common scheme of taxing and regulating marijuana like alcohol.
And you're very specific, and I'm not.
Yeah.
Tell us how there's such substantial degradation of the medical marijuana.
Yes.
That it becomes a different policy statement.
Right.
Okay.
So, Your Honor, the current medical marijuana regulations, which are 935 CMR 501, those cite 94G 62 times. So what we're doing here, and this is an important point, which is we're taking medical back to a point. We're taking it back and we're starting from scratch. And that is kind of, I think, one of another fundamental problem here. And also with respect to our host community agreements, which I know maybe the court doesn't view as consequential, but we had a lot of problems with host community agreements. And in 2022, the legislature fixed those problems. And the harmful part about eliminating it for medical is that all the problems that this court saw in Mediri, right, when it decided Mediri, or at least it recognized the Mediri, which is this pay to play and the impact fees, the legislature dealt with that. So why, if this petition its goal is to constrain the use of recreational marijuana and continue medical, I think that's really key, is a plain language. When the voters read this, they think the medical program is going to continue, and it's not. We're going to start from scratch on rulemaking. We're going to lose host community agreements. We're going to lose social equity. It's substantially not the same. I know I'm running out of time, but I think it really pivots well to the summary, which is, Your Honor, the summary does nothing to talk about the impact on the medical program. And one of the things if I could highlight, because I got a minute left, there's one thing that I think is absolutely fatal to this summary, which we did not highlight necessarily in our brief, but I think it's really important for the court to see. And if you look at the Attorney General's summary, and I'd like to read it, it says, the proposed law would change the type and amount of marijuana that may be legally possessed in Massachusetts by repealing the laws that legalize, regulate, and tax the retail sale of adult recreational marijuana in Massachusetts. This leaves out production, this leaves out cultivation, and most importantly, it does not inform voters of the home grow provision. Voters right now, even if you've never sat foot in a retail dispensary, You can grow 6 plants at your house right now. Nowhere in the summary and nowhere in the petition can they glean, can the hobbyist that is growing marijuana or anybody, can they see that the home grow provision is getting eliminated? That I think by itself is fatal. And I think, I'd like to, there's other aspects. The biggest aspect, second biggest aspect to say of the summary is the fact that they're not talking about the elimination of the social equity program. That is a very important program. And for the AG to call that minor or just a footnote, it is not, it should continue in the medical world. I mean, that's what its intention was. And they are not informing voters of that. The social equity businesses themselves, but the plaintiff here, and I should have noted earlier that Caroline Pineau is here. If I forgot to do that, maybe I did that already.
Can I ask just one question related to your
point?
So home growth.
Yes.
This is not an area of expertise, but home growth, home growth makes sense in a world where recreational marijuana is legal. Where only medical marijuana is permitted, why is it so unrelated to eliminate home growth? I just don't.
I don't think it's unrelated. I think it should be in the summary, though. I don't think it's unrelated to eliminate it. I think that's consistent to eliminate.
But if it's consistent, does it need to be in the summary?
Well, Your Honor, I know you didn't like this before, but I go back to if in Hensley, and Hensley, that this court was concerned. I know it didn't rule on it, wasn't dispositive. It was concerned about the definition of marijuana products, right? That was a concern. They kind of parsed that out. It didn't ultimately be dispositive. Mm-hmm. If this, I can tell you that the proponents of this petition would be jumping out of their shoes if in question 4, which was Hensley, we didn't mention that you could grow 6 plants at home. I think the voters have a right. That's just one. That's one feature, and there are many other features. And I think the social equity component. I know I'm running on time. The recent amendments. We did provide a 16L letter in this case, Your Honors. And one of the things I'd like to highlight from the recent amendment is that the legislature, in reforming the marijuana laws, led again under 94G and other statutes, gave a 2-year exclusivity to medical licensees for social equity. And so this is, again, goes to the unrelated nature of the social equity. Why, if the purpose is to continue medical, are we eliminating it for social equity? It's going to, that, and nowhere in the summary is this elimination of the social equity program mentioned. And if the, that is it's a million and millions of dollar grant program designed to remedy the harms of marijuana prohibition. At a minimum, even if the court doesn't agree that it's unrelated, that should be mentioned in the summary. I'll also say there's some other things, Your Honor, just quickly. The enforcement of contracts. There's thousands and thousands of companies that have entered in, or individuals have entered into contracts with these businesses. I think it might be important for them to know that if this passes and they're voting on it, that the enforcement of contracts is a matter of public policy. Statutorily, we're not going to say it's a matter of public policy that the contracts will be enforceable. Likewise, which I think is an incoherent part, this eliminates the ban on public consumption, right? And eliminates the ban on having open containers in cars. If, that I think that's a difficult question or issue for the voters. Why, if the goal is to constrain medical use, are we making it easier to publicly consume and have open containers of marijuana in the vehicles? It's not consistent. It's something I'd like to know. It's one of the most common complaints about the adult use program, I would say, is people don't like it. I don't like it. People smoking in public. And this is going to eliminate that. Those are just a few. We have others in our brief, but that we think are deficient in the summary do not show the main features of this initiative.
Okay,
Thank you, Your Honor.
thank you. Okay, Attorney Macri.
Good morning, and may it please the court. The petition before the court is much like the one that this court faced in Hensley 10 years ago. The key difference is just that instead of proposing an integrated scheme that seeks to legalize recreational marijuana, the petition before the court seeks to dismantle the scheme that Hensley erected and make other changes that constrain the use and sale of recreational marijuana. I'll start with Appellants' arguments about related subjects. Nearly all of those arguments are already addressed by this court's decisions in 2 cases. Those are Weiner and Hensley. The principle that comes out of those 2 cases is that an initiative petition may propose provisions that deal with the downstream effects of the core provisions of the petition. For example, in Weiner, as the court may recall, the core of that petition was to allow food retail stores to sell alcohol. It also included a provision that that required new procedures for demanding ID from persons under 21 years old when they were buying alcohol. That didn't just apply to food retailers. It applied to everyone. And this court said that was okay, even though the blast radius of that provision extended beyond what the petition was changing at its core, because it was at least related to the core of the petition. And it addressed one of the downstream effects of the core of that petition, which was liberalizing the sale of alcohol to a broader set of retailers. Hensley more specifically held that just because a petition dealing with recreational marijuana has some incidental effect on the medical marijuana space, that doesn't create a related subjects problem. And the same is true here. Under both of those cases, the types of provisions that appellants have highlighted are ancillary measures of a petition dealing with recreational marijuana, and they don't diverge from that core aim sufficiently to create a related subjects problem. For example, the trust and the social equity program. There are two reasons why that's tied to the petition's core aims of constraining recreational marijuana. First and most obviously, the funding for those programs predominantly comes from the tax of recreational marijuana. If we're not going to tax recreational marijuana anymore and take away those proceeds, then the trust and the social equity program are substantially diminished. And so by getting rid of those programs, the petition is dealing with a downstream effect of that lost revenue. The second reason is that the purpose of those programs is to help secure opportunities in the marijuana industry for communities that have been disproportionately impacted by the criminalization of marijuana. Those opportunities are going to be substantially diminished by the petition if it's passed, because recreational marijuana, which is the majority of the marijuana industry in Massachusetts, will be gone. So that part of the petition merely seeks to deal with downstream effects of the petition's core aims.
Is that important enough that it should be in the summary?
No, Your Honor. The summary, this court has reiterated this many times in Anderson, in Hensley itself. The summary does not need to address every single detail of an initiative petition. Indeed, it cannot. And this petition is actually a good example of why that's the case. This petition proposes to do a lot of things. As Appellants Counsel mentioned, it seeks to repeal all of Chapter 94G. That is a fairly big change, and there's not necessarily a related subjects problem or a summary problem just because of that. Given the breadth of that change, the summary must provide an abridgment, as this court has characterized it, of what the petition is doing. And the summary does that when it says the proposed law would repeal the laws that, quote, legalize, regulate, and tax the retail sale of adult recreational use marijuana in Massachusetts. A voter faced with that summary understands that what this petition seeks to do is a big deal. It is a big change. And encapsulated within that is going to be the repeal, or going to be effects on many things that are supported by the tax revenue of marijuana and aspects of regulating recreational marijuana, including aspects that were enacted by the legislature in response to the petition that this court reviewed in Hensley. Turning to appellants' arguments about host community agreements, this too is okay because of what this court said in Weiner. Host community agreements, for one thing, they're not being eliminated by the petition. What the petition does is it eliminates the requirement that all marijuana establishments enter into host community agreements. But that requirement did not pre-exist the legalization of recreational marijuana. It came about in 2017 after recreational marijuana was legalized, and apparently in response to the fact that recreational marijuana was legalized. It stands to reason that if the petition is repealing the laws that regulate recreational marijuana, some of the safeguards that were put in place in the wake of recreational marijuana legalization are also going to be repealed or changed in various ways. This is analogous then to the change in Weiner, which imposed new procedures for demanding identification from persons under 21. That was a safeguard that was enacted in response to the broadening of the types of stores that would be selling Alcohol, this is sort of the inverse of that. We're doing away with the safeguard that was enacted to deal with recreational marijuana, or the petition is doing away with the safeguard that was implemented to deal with recreational marijuana, because recreational marijuana is, at least commercially, is no longer legal. Your Honors, with that, I am open to any questions from the court, but otherwise I will
Could you
rest.
talk about that one other one that you did not, about the enhanced penalties and how that's related?
Yes, Your Honor. Well, the core purpose of the petition on its face is to curtail recreational marijuana. A national outgrowth of that are changes to penalties, and that includes not just penalties for adults, but penalties that relate to minors or emerging adults, such as 18 to 21-year-olds. The requirement, the related subjects test does not require that every part of a petition is a necessary result of the core parts. All the related subjects requirement demands is relatedness, operational relatedness. And it's easy to see that if the aim of the petition is to restrain recreational marijuana, then the penalties might be tightened to that end, and they are.
I guess the thing we've been struggling with all morning is how much in a summary does the average voter need to know? And it may very well be that the average voter may not necessarily be excited about what happened 10 years ago, but is necessarily not signing up for enhanced penalties to folks either. I mean, so, you know, we're doing this kind of divining here, where it's not in there, and when we're talking about the relatedness, why would I need to have one if I wanted the other?
Well, Your Honor, I'll answer that in two parts. First on relatedness, and then on what the summary provides. As to relatedness, that there is a dividing line somewhere, but there's nothing here like what we see in cases like Carney or Cusa, where we're tying things together that are relatively large questions, sometimes in distinct policy spaces, and hitching them together. For example, in Carney, the petition there proposed to increase criminal penalties for certain forms of animal cruelty, and also to render illegal dog racing. And one of those provisions had been proposed in a petition several years earlier and was rejected. And this court had a concern that, well, you're taking something that was unpopular and that failed to pass and hitching it to something much more popular, the enhancement of penalties for animal cruelty. Here, we're not talking about anything like that. We're talking about a relatively modest change to the penalties. Currently, as it stands, persons under 21 in the Commonwealth cannot legally possess marijuana. That stays the same. The penalties for possession up to certain amounts are merely a civil penalty of $100. That stays the same. The only change, at least as far as the emerging adults provision goes, is that persons between the age of 18 and 21 will now need to take a class that is already required for persons under the age of 18 if they're caught in possession of marijuana. You know, as to what the summary provides, I think this petition is a great example of why the summary just can't cover everything. And the Attorney General isn't necessarily in a great position to judge which details need to be highlighted, at least in a petition this comprehensive, which ancillary details need to be highlighted above others. And I think the summary here, what it aims to do is abstract that away a little bit. I mean, when it says that this petition would repeal the laws that regulate and tax and legalize recreational marijuana, a voter is going to understand that's a big deal, and that if they want to understand more, they can dig into the other materials, as in the yes/no statement and the other information that's provided in the voter information packet.
So if you're trying to accomplish, or at least if it accomplishes two very different policy choices, that's okay.
Well, Your Honor, I'll answer that in two ways. First, to an extent, yes. I mean, if what is meant by that question is it okay to put a voter in a position where the petition achieves both something the voter likes and something the voter doesn't like? That is okay. This court has said that in Hensley and other cases. A voter is always free to vote yes or no and weigh the costs and benefits of the proposal. And maybe this petition does that for some voters. The question is just, is it hitching together two things that are so unrelated that the voter is really put to a tough choice, especially where there are other elements like in Carney where something unpopular was being hitched to something popular, or in CUSA, where potentially large questions were obfuscated or hidden from view. This isn't that. The summary is very clear, that the petition is very clear. Something big is happening here, and if the petition is enacted, and it's up to voters to read the fine print if to the extent they're worried that that might affect various details of the recreational marijuana scheme.